PDP, that may be called for your lordship. Hello, please.
May I please, your lordship?
Mm.
I recommend sir item number 8, lordship.
Mm.
Matter may be exempt for a day, lordship.
Learned counsel for the petitioner, your name?
B. Dr.
Dr.
On behalf
Read
of
for adjournment.
AVT.
Please the matter on 21, 5th of May. Item number 8, no? Yes, le?
May I please, your lordship? Lordship, in regard of item number 21, we have made a request for visit. Lordship may kindly take up the matter at 2.
All right.
Obliged.
Whom proceeded to 21?
May I please, your lordship? May I please, your lordship?
Mm.
Item number 11, lordship.
Mm.
Matter may be adjourned for the day, lordship.
Learned counsel for the petitioner, Mr.
This should be.
Please, Suti has bid for adjournment. Please the matter on. You have the CD? Issue reminder to for the CD.
No, so that maybe lordship.
Hmm?
So that may be given lordship.
1st May.
So that.
1st May. 1st May.
I love it.
Item number 1.
May I please, your lordship? My lord, over here, the cases of 3052, my lord, in respect of allegation is that SR was filed in respect of missing of 2 bikes, my lord.
Mm.
And ultimately it goes to show it was recovered from somebody else, my lord. That is from Karbi Anglong. We are, my lord, in a night bus. Those, as your lordship is aware that night supers are there running from Manipur to Guwahati. We 3 are working, my lord, as a conductor and helper. What happened, my lord, in our bus, rupees 4 lakhs was found. And ultimately the driver said it was found in the cabin. The driver said it was one businessman from the Manipur has given to delivered to Guwahati, and Jimma petition is filed in respect of that money. But in this case, I have been shown arrest, and from 17 March, I am behind the bar. But incidentally, my lord, the charge sheet has been filed, and the ground of rejection of my bail is the last order, my lord. Well, possibly that is untenable.
Untenable, why?
Because on the ground, my lord, this may not be sustainable before my lord. That only because I'm not from Assam. That is the reason my bail has been denied. If your lordship looks at page 22, Annexure 7.
You're behind bars in connection with this case.
My lord,
Shown as arrested. You're shown as arrested in this.
yes, yes.
When,
My lord,
when were you arrested in this case? In this case, not earlier case.
my lord, shown arrest. My lord, only 1 minute. My lord, paragraph 8, my lord, that is on 20th. On 20th, this application from the IO of Garchuk PS came before the learned court below.
Have do you have a forwarding report?
My lord,
Forwarding report?
yes, my lord. Would your lordship be pleased to see, my lord? First, I would like to draw your lordship's attention to page 15, only for a minute, my lord.
Yes.
My lord, if your ground of arrest, second paragraph, my lord got it. As per information, My lord, as per information given by the arrested accused, Gainmanglung Gulme, 32 years, 5 more bikes have been recovered, which are so and so. My lord, would your lordship be pleased to see number 4?
Mm.
4 is the last number is, my lord, 8699.
Mm.
My lord, and next, my lord, 8699 is corresponding to the FIR, my lord, page 17. I'm sorry, my lord, I'm making it a bit disturbing.
Mm.
Would your lordship be pleased to see the page 17 correspondingly, my lord?
Yes.
This was the FIR. The first bike is, my lord, 8699. Page
Yes, yes.
and my lord, second one also, your
No,
lordship may
it's
see in
okay.
page
When
15.
you arrested, I want to know, yes, you are in
My lord, shown arrest, this is the order in page 20.
page 20.
Yes, my lord.
Yes, PP.
Charge sheet has been submitted.
Yes, yes, charge sheet has been submitted.
Moreover, his role is also stated here in the forwarding report, Lordship, page number 15,
Mm.
as, may I read, Lordship?
Mm.
Also as led by the, in the ground of arrest, first, second, third para, Lordship,
Mm.
as led by accused, another 4 persons, namely so and so, Lordship, his name is also there.
Mm.
And as apprehended at Jorat, along with one bus,
Jorat, no, Jorabat.
or Zorabat, sorry, Lordship, along with one bus, so and so, which was used to transport theft vehicle to the state of Manipur illegally. So his role is also there.
My lord, over
So
here,
at this stage, without looking into the materials,
my lord, over
scan
here,
copy, it is difficult. Lordship.
my lord, over here, the 4 persons, including the driver, has been booked. Only thing is that, my lord, they felt very uneasy because 4 lakhs rupees, my lord, not even a single rupee could be misplaced because of the telephonic conversation of the businessman. And ultimately, I was shown arrest in this case. And these 2 bikes were, my lord, from this gain.
There are 3 persons, no?
Yes, we are
Yeah.
3%.
Raju Shankar, Muhammad Akbar, and Levon. Okay.
Yes, my lord.
Oh.
The 4th one is the driver who owned that the money has been given to him. My lord, the money was found in our bus in the cabin. And the driver said, yes, it is given by one businessman. And there is a Jimma petition in respect of that money by that businessman saying that I have given the money to the driver. I'm not before. The driver is before, not before my lord. Only the thing, conductor and the helpers.
You were arrested on 15-3, no?
Yeah, 15-3, my lord. And my lord, arrested what? In connection with the person, my lord, this person who, from whom in Karbi Anglong, the bikes were recovered from this girl mine. He is not before this honorable court. Totally different. We have been, my lord, while coming from Manipur, we have been, well, in Jorabat, this, because of the passengers' needs and requirements, the normally bus stops, breakfast and, my lord, washroom, etc. At that time, as a normal routine, they entered and they found in the cabin the money. And then immediately they called us. They said, what is the money about? Then the driver owned up. He's not before my lord. He's the driver. We are conductor and the helper. The driver said, yes, one businessman has given to me to give it to the Guwahati businessman and in return takes the good. Why they do it? Because the goods rent, the fare comes to about 20,000, 30,000. That is the reason why the drivers normally carry. I'm not on that. But I've been shown arrest against in respect of stolen 2 bikes which were already recovered from another person in Karbi Anglong.
Not I. There are 3 of you.
No, 3 of us. This is the conductor and the 2 helpers. We have been shown arrest in a case where the bikes have been already recovered from another person, and that is the in the forwarding report
But you
itself.
have been antecedent. You are shown as arrested.
Yes, I've been shown as arrest in that.
The
But-
earlier case, what is the earlier case relating to?
my lord, that only that around that because of that 4 lakhs rupees.
One is relating to 4 lakhs rupees and the other is relating to bike theft.
Yeah, 2 bikes. And 4 lakhs rupees also, my lord. This is the driver owned up and bikes already this it was recovered from Karbi Anglong from another person who was arrested in Karbi Anglong itself. And in fact, my lord, after the
Gorsuk
recovery,
PS, this present case is Gorsuk PS case number 80 of 2020.
yes, my lord, and the shown
Please read
arrest
the
is in
FIR.
page 20.
Please read the FIR of the of this case, then we will go to the shown arrest case.
My lord, FIR is this. My lord, page 17. My lord, got it. With
Page
due res-
17.
with due, I've already shown, my lord, these
Mm.
two,
Yes, yes,
not named or anything. Ultimately, it was found. It was recovered from another person.
yes, it's okay. Please read the FI.
With due respect, I have the honor to inform you that today on 12/3/2025, at around 2:45 p.m. to 3 p.m., some unknown culprits stolen away me and my friends below motorcycles from the parking place of Royal Global University campus, Betkuchi of Gorsuk PS jurisdiction. Therefore, I request your honor kindly to take necessary steps in this regard as per law. These are the two bikes.
So this, do you have the seizure list?
Yes, my lord.
No. With this record,
No, these are, my lord, I have got the thing. If your lordship permits, I've got the certificate copy. I can show the certificate copy. But to my knowledge, is already people have already took back the vehicle, Jimma, my lord. My lord, number
and what
two.
are, both the vehicles have been taken, no?
Yes, yes.
From which accused it was recovered?
My lord, this is in the forwarding. It is given, my lord, from one Gulmai. My lord, that is page.
Okay, that name is there.
Yes, page 15, and it is in the
Second-
it is in the
second
FI,
paragraph.
it is in the charge sheet itself. It is in the seizure list itself.
Have you annexed the charge sheet along with this record?
No,
Charge sheet or case, no?
it's already charge sheeted. I'm not gone for quashing. I'm go just for bail
No,
on
no.
this ground, my lord.
Even then you should annex the charge sheet. Charge sheet, serial list, everything you should annex. Otherwise we'll call for the scan copies then. We'll call for the scan copies then. Let us call for the scan copies.
It can be, my lord.
Yes, call for the scan copies of the child court record along with the scan copies of the CD. This is the matter of second. You can take this back. We'll get all the seizure list and everything.
My lord, could it be 30th from here only, my lord?
2 nights, okay?
It is 3. Deeply obliged.
Wait, please, your lordship, police report was called for in this matter.
I have not received it.
No. Police report as called for is not received. Issue reminder, list the matter on. Interim order shall remain in force till then.
Much on next.
Item 3. Item 4.
Oh,
My lord, it is a 3-year bail application on behalf of petitioner Narzima Begum. As per the FIR, a small dispute arises on court February 2025, In fact, Azhar was registered on after a lapse of 10 days, And as per the Azhar small dispute arises, we had under same roof, family members, 2 1 under, Out of 5 Azhar and accused, 3 already been given pre-arrest bail, by this honorable court, So we are living under same roof, same is fixed on 9th May, for perusal of case diary as
where's
well
the
as
FI?
medical report, Azhar is page number 14, my lord.
Please read.
সন্মানপূৰ্বক বিনীত নিবেদন এই যে যোৱাকালি ৰাতিপুৱা মোৰ পত্নী জিলৱাৰা বেগম আৰু নাৰ্জুমা বেগমৰ মাজত সামান্য কাজিয়া হৈছিল যদিও গধূলি 6:30 মান বজাত উপৰোক্ত পদকীয়া কেইজনে অনাধিকাৰ ঘৰত প্ৰৱেশ কৰি ইছমাইল আলীয়ে May I please, in which case report was called for, my lord? Whether any case was registered or not.
I have not received any written report, Lordship, but one statement is there, Lordship. No case registered. One petition was received against him regarding land dispute which is under inquiry. So there is a complaint.
Petition was received against
Against him.
land dispute,
Lordship.
which is under inquiry.
Lordship.
According to the new BNS, there is an inquiry going on
Lordship.
relating to the land dispute.
First inquiry need to be done.
You want interim protection?
Yes, ma'am.
No case has been registered, but still,
No blanket protection can be given without registering. How can be given, Lordship? On what ground?
Malad, actually, since we are apprehending arrest, Malad, because as my learned friend already stated that there is a
but
complaint.
no
which is
case has been registered as yet.
a
You
com-
see, inquiry, I think first case is registered, thereafter inquiry is conducted. First
But-
case is registered according to the new BNS, so
Okay.
thereafter, so far as I could perceive, thereafter inquiry is conducted. So now no case is registered, why should I protect you without any case?
One thing, Malad,
No, no,
there is a
no, no,
complaint.
this is not a good submission. Without any case, why should I protect you? I'll dismiss it.
Okay.
You have a written report or you will-
No, some, one of the APP have written it, Lordship.
who is it?
One of my APP colleague, Lordship,
Okay.
is written. here.
The report as called for is not received, issue reminder, list the matter on.
Ask me, I think.
Item 6, fair hearing. Item number 6.
Standing counsel,
Here I am.
oh, he has to be here.
Shall I
Item 7.
follow at 2 months? At 2 months. Wait, your lordship.
Milord, case of mobile snatching, Milord. After snatching of the mobile,
Available.
I was taken, Milord, for
Do you
recovery,
have a
but
CD?
No, it is not available.
I'm already on interim, Milord. This is already 11 interim was granted. 25 I was arrested, Milord.
Why were you granted interim?
Milord,
For exams?
for exams and Milord, I suffered bullet injury in the incident, Milord. When I was taken in the name of recovery, thereafter I was sought at, Milord. And 11 order is 11 Milord. Another case was registered. There also I was granted, Milord, bail, Milord, without even producing the case diary. But 19-year-old boy mobile snatching case, Milord, but the CD is required. Page 14 is the FIR. Milord. Well, I'm already on interim, Milord, from 11 onwards. Order is 11
Your exams are over.
Exams are over.
Now it's your duty to surrender.
Lordship has to consider the case diary first, Milord, because 60
No,
days
no.
mandatory period is also over, Milord. I have my injury are not recovered because of the injury.
Your.
And they are
No,
3
no,
days.
this is not justified.
The police.
Your interim order was extended
Yes, Lordship,
till
but
today. So what was your
the
duty?
duty of the police was to send the case diary to this court for perusal. The police are deliberately not sending the case diary.
No, no, you must surrender. You are given interim.
I will surrender, Milord, but
And,
first, Lordship.
First of all, this order was wrongly passed. I have passed this order, it was wrongly passed.
No, it was passed by Honorable Mr.
Interim order
Justice.
could not be extended in this manner. You were given a few days' time.
And in the FIR says, my lord, of course, the objection file is made very serious case, but FIR filed by the same informant, my lord, who says, I was the witness, he has not named anything about us in the FIR. FIR is a page 12, my lord. Had a long-standing dispute with the accused. Just 2 days ago, they had threatened my husband, stating that they had made a new message down to killing. My husband had previously filed a case against the accused number 1 at Hodai police station. And also a non-FIR case number so and so. I lodged a complaint against the accused at Hodad police station regarding land boundary dispute. Due to my husband's post-mortem and other families, there was a delay in filing the FIR. Who are the accused? My lord, names of the accused. Surendra Chauhan, Mahendra Chauhan, Nayak Chauhan, Rajesh Chauhan, Mukesh Chauhan. We are not a real name. We are our own relation. Actually, later on, the police made the case that we harbored them. That not related to us. Only at least the lady with the child to be. Others they will also will examine the case diary and then grant or reject the bill.
That petitioner number 1.
Yes. Only for that.
How old is that baby?
How old? 2 years only.
2 years.
Supplementary.
So in the may I now?
Yes.
In the preliminary investigation, the police has seized their SIM card and the CDR has been obtained. And it is found that they are connected thoroughly from the very beginning with the named accused. So it is very clear is that their involvement is very much there and the total investigation will.
They're behind bars for how many days?
Now already 1 month 4 days. 18th March they were arrested.
It is a murder case, Lordship.
FIR was filed on 2nd of February. But they were arrested on 18th of March. After about 1 month, 18 days they were arrested.
PPA.
The forwarding report, Lordship, their role is there, Lordship. It is clearly stated, this Lal Chauhan, along with his wife Ramba Devi and the daughter Durga Chauhan, all are named in the petition, all are the petitioners, Lordship, deliberately conspired to shield the accused, that is Kanchan Chauhan, from the authorities after the murder of Jitendra Chauhan. The trio actively planned and provided logistic support to help the accused evade arrest. Moreover, Lordship, it is also there, according to the CDR, they are constantly in touch with this Kanchan Chauhan, Lordship. They are harboring, Lordship.
Harboring is not available.
In the our location is showing that they were present at the time of the occurrence of the offense.
Moreover, Lordship,
well, that's the
62
thing.
is also there, conspiracy is also there, Lordship. 61-2, not only harboring, 61-2 is also there. So it is not only death, murder along with conspiracy, Lordship. They are conspired, pre-planned. It is not that they have already, only harboring is there.
not be wrong that they are the key persons. They only has the conspiracy.
But police has only able to arrest any of the other real accused.
They have to be difficult, Lordship, because the PM report is also necessary.
The murder is a brutal murder, Lordship.
On hand,
Committed with
the body, Lordship.
If I is the first hand report, my lord. Because the informant says she rushed to the spot and found the body and took to the hospital. That means she had seen the accused who hit him.
Okay, then that lady with the child.
Lordship, let the CD speak, Lordship.
Humanity demands one of the lady with the child.
Okay, let us call for the CD. It's a murder case. Let us call for
No,
the CD.
murder case,
Call
but
for the CD. It's very short date. Very short date. Call for the CD. List the matter on 1st May. But that babies are provided every food, milk, and everything in the jail up to 6 years.
well, jail, my lord. They have to
Very
sleep.
sad, but
Yeah, they have to sleep on the floor, my there is a
I
spot
feel
also.
sad.
Your lordship knows.
Yeah.
With your vast
Very
experience.
short date. Very short date.
Thank you.
I can take.
Short date, दिला ना?
Okay.
1st May.
First of all.
May I please your question? Well, the scan copy was called for. searched case, my lord. These three petitioner, they were arrested on, my lord, 16/1/2025. FIR was dated 15/1/2025.
Have you gone for the scan copies?
This is a,
Where is the?
Now it is
FI,
just
huh?
stage of production stage. And there is
this on committal stage, my lord. Committal stage. If we go through the, my lord, we have been supplied with the, my lord, copies. I have gone through the copies, my lord.
Hmm.
If we go through the copies, my lord, only allegation against, my lord, Osman Ghani is there that he inflicted one blow on the nose, my lord. Rest of the, my lord,
Osman
petition,
Ghani and Ajiran Begum.
Ajiran Begum is the, my lord, the wife of the, my lord,
Osman
deceased.
Ghani.
Wife of the deceased. And Usman Ghani is the, my lord, the cousin brother of the, my lord, petitioner number 1.
Okay.
And, my lord, petitioner number 3 is the son of the, my lord, deceased, my lord. Because, my lord, the deceased married, my lord, for the second time, my lord. So there was a village male was there, my lord. Boitok was there. In that Boitok, my lord, some quarrel was there, my lord, between the husband and wife, my lord. Then Usman Ghani dealt a, my lord, blow on the nose, my lord. And the person present in the, my lord, Boitok, they have, my lord, separated them. And in the morning, my lord, that victim found to be died, my lord. Absolutely no allegation against, my lord, Aziram or Asghar Ali, my lord. Whatever allegation is there, my lord, Osman Ghani dealt a blow on the nose, my lord. They will face trial, my lord. So for fair trial, my lord, I pray that they may be released on bail, my lord. Because we have the supplied with all the copies, my lord. I have gone through the copies, my lord. And one of the, my lord, accused petitioner, my lord, he approached before this honorable court. He has been granted, my lord, the privilege of, my lord, anticipatory bail, my lord. 4 persons have been, my lord, seated. These 3 and another. That 4th person has been given, my lord, the benefit of anticipatory bail.
There are injuries on his abdomen also.
Abdomen is there, but from the, my lord, the evidence of the, my lord, these
That
witnesses,
was the result of the injuries sustained over the abdomen. as described.
abdomen, that is
Lacerated
there.
injuries on the abdomen.
Yes. But whatever, my lord, the eyewitnesses versus, my lord, that a blow has been given on the nose. That injury is also there on the
No,
nose.
no. They have assaulted him with hands,
My lord,
bare hands.
not all the persons, my lord. It is Osman Ghani. It is their belief that, my lord, in the night time, the other accused person is assaulted. It is their belief, my lord.
How many days they're behind bars?
My lord, they were arrested on the next date, my lord. FIR on 15th, they were arrested on 16th. And, my lord, charge sheet was very promptly submitted on 28/2/2025. Within, my lord, 45 days. We are ready to face trial, my lord. What for, my lord, they have to be remaining behind the bar, my lord. They will face the trial, my lord.
Have you prayed for bail in the Sessions Court?
Sessions
Shall-
Court, my lord, yes. I have annexed that order at Lordship will find it page 40, my lord.
I'll check.
at page 40.
I'll check.
Yes. I had been asked to go back to the, my lord, the magistrate court, my lord. This is a 302 case, my lord. How magistrate will grant us bail?
They are all implicated,
They are all implicated.
implicated.
But my lord, I have gone through the statement, my lord. From which statement, my lord?
164, I will read it out. 164.
Granted in the name of the PS Trading, a firm. And he was stood as a guarantor. He deposited the title deeds of the land. In 2019, they defaulted. So notice under section 13(2) was issued under the Surface Act against borrower and against the guarantor, who is the informant here in 2019. Now, then he filed an FIR, this FIR, saying that he went to the bank and for a home loan and he deposited his title deeds and thereafter the loan was not sanctioned and this affair. Now, Lordship has found that the recovery proceeding, already the DRT has issued the certificate against the informant and that farm for recovery and for selling of this mortgage land. This is how a criminal law has been misused, is an example. In spite of that, we are already on interim bail. Our statement has been recorded.
Yes, yes.
We have received the case there, my lord. My lord, what my learned friend has submitted, my lord, it is absolutely, my lord, incorrect, my lord. For that purpose, my lord, I'll take your notice to the FIR, my lord.
Let it take
No,
to the
let me-
Lord.
let-
I am without
Let me
wasting the valuable judicial time. I am just in nutshell. I am submitting. Now it is believable, my lord, that a person went to the bank for a home loan. He deposited the title deeds without sanction letter. And then thereafter he came to know that no loan was sanctioned and his title deed was misused for sanctioning of another loan of BS Trading. Now that has been adjudicated. Lordship, kindly see the debt recovery certificate. Debt recovery certificate. This is a order by the recovery officer against the BS Trading. A proceeding was drawn up under the Act of Surface. Matter was adjudicated and recovery proceeding was drawn up. This land is under the sale under the DRT.
Okay. What do you have to say?
My lord, if my learned friend permits, my lord, then only I can
No,
submit.
no,
My lordship may kindly come to page number 15, my lord.
Yes.
My lord, page number 15, my lord, what is the written in the FIR, my lord? This is very important, my lord. My lord, page number 15, I am reading from the page, line number 4, my lord. In the year 2018, I approached branch manager of Central Oriental Bank of Commerce, Institute branch, and requested him for housing loan of rupees 10 lakhs for the purpose of construction of RCC building over my plot of land. The bank manager, the then bank manager was Omid Kumar Jha, stated the process of sanction of loan and asked me to submit the original documents of sale date, Zobamude land revenue received, cadastral map, base map, and other related documents of my land. The said bank manager also took my signature on various documents, my lord. These are very important, my lord. What my learned friend has submitted is absolutely incorrect, my lord, because whatever I am submitting, my lord, it is on the basis of the materials in the case diary collected by the investigating officer, my lord. I have got a strong objection, my lord, granting him absolute bail, my lord. And for that purpose, my lord, I am just reading the FIR, my lord. The said bank manager also took my signature on various documents which I was never allowed to read. After the due process, the bank manager asked me to come after 1 month and assured that loan amount will be credited to my account. After 1 month, I visited the bank on several occasions, but the bank manager on each and every occasion failed to credit loan in my account. The manager kept on assuring me that the matter is under process and it will take some time for the credit of the loan. After that, in due course of time, I became frustrated and left all the hopes to get any amount of loan from the bank, and due to my involvement in some business, I could not approach the bank manager frequently for any update regarding sanction of my loan in my name. Thereafter, suddenly on my lord, these dates are very important, my lord. Thereafter, suddenly on 12/11/2019, I received a notice under section 13(2) of the scrutinization and reconstruction of financial assets and enforcement of society interest act 2002, issued from the Oriental Bank of Commerce Circle Office, Guwahati, stating that I stood as a personal guarantor of Messrs BS Trading, account number so and so. My lord, what he has done, my lord, when he deposited the original, my lord, land documents, he, my lord, used the manager, my lord, in connivance with the person who obtained the loan, my lord. They connivance each other, my lord, they conspired each other, my lord. Then they took a loan, my lord, that person, my lord, who in whose paper the loan was sanctioned, my lord, in his name. And my lord, this person, my lord, informant, he was shown as an, my lord, guarantor, my lord. Because, my lord, he submitted all these original documents, my lord. So there are implicating materials, my lord, collected, my lord, and this is the, my lord, short note of the investigating officer, my lord. I just place it, my lord, what he has found from the investigation, my lord, after my lord, filing of this FIR, my lord. Lordship, may kindly spare with this page to, 2 pages of the, my lord, of the information, investigating officer, my lord. And my lord, the person is over, my lord, the loan was sanctioned, my lord, he is absconding, my lord. So, my lord, to arrest that person, my lord, is very necessary, my lord, and custodial interrogation of this person is also necessary, my lord. Because these are, my lord, government money, my lord, private, my lord, public money, my lord. It is a commercial offense, my lord. They have misused, my lord, public money, my lord, in this manner, my lord. Total fraudulent manner, my lord. Thus, these 2 pages, my lord, what he has done, my lord, this is, my lord, clear from the case diary.
One thing, my lord, I request, my lord, that the whether any notice under section 41 was issued against the principal borrower, against whom the conspiracy, this story has been crept up.
No, there actually this person, he has with his handwriting, he has filled up all the forms.
Absolutely
This
correct.
person has taken loan, but he was shown as guarantor.
No, I'm explaining, my lord. Then the benefit of the loan, who has gained? BS Trading. Now, that borrower against whom the DRT already issued certificate against it, he has not made any acquisition here. This is a surprising fact. What happened behind the story is this land has been sold by this informant to one Rajiv Shodhia, a popular singer who died, unfortunately. He sold out that mortgage land to one Rajiv Shodhia. And when it came up in the papers and social media, then this case has been, the police has submitted final report earlier in 2022. Then this story has been came up. Give me an liberty, my lord, because this investigation cannot proceed. The DRTA has already seized the matter, and all the mortgage document has been perused by the DRTA. Because so far the system, the statutory scheme is concerned, it has to be investigated by the DRTA, Debt Recovery Tribunal. Then Debt Recovery Tribunal adjudicated the matter and issued the certificate, debt recovery certificate.
Just a moment.
So I will produce all those documents before this honorable court of the DRTA proceeding. The police has no power to nullify the DRTA certificate.
Just a moment, just a moment.
That I will produce.
You are saying that while this loan was being taken by another person, this person sold his land to Rajiv Sodhi.
Yes, this informant.
That land,
Then this land, mortgage land,
that same land he sold to Rajiv.
Rajesh Shodhia. And then this copped up the study. What is the he is a chief manager of a bank, my lord. So this loan has been granted to BS Trading.
No, it's okay.
So therefore, I will
It's
produce,
okay.
my lord, for the satisfaction of this honorable court, because the similar case has been also in the Silchar against the bank manager. That this is the going on now. Now by that way, the defaulter, now the NPA account defaulter take the gain with the conspiracy with the police. I must say, because since the learned PP has raised this objection. So therefore, my lord, how can a criminal proceeding can nullify a DRTA proceeding? This is a question here. I will produce all those documents, my lord. Give me some 1 month time.
You will extend it and then you put
Yeah,
it.
no, already my statement has been recorded. So there is nothing that any further interrogation is required. My statement has recorded for 3 times. 3 times. Section 41 notice has been issued.
You need not go and record your statement again for the 4th time.
No, already
We'll extend
police
it.
has said
You
that
are
no
saying
more
that you
statement
have
is required. No more statement is required. I am stationed in Calcutta. I came for 3 times for recording my statement. And this is the story.
If your lordship, my lord, pays his statement also, my lord, it will reveal, my lord, how he has done it, my lord.
That
How he has
one
done
will
it.
fill up with his own handwriting, but.
And that naturally, my lord.
But that was.
Who will fill up?
No. That bank manager.
Yes, who will fill up the mortgage document?
No, why will the bank manager fill up the?
Absolutely. Is there any norms that the one peon will fill up? The mortgage document,
I don't know, I haven't seen bank.
that this is
manager.
not the RBI guidelines, that the bank manager is restrained from fill up the mortgage document. What is this?
I don't know. I haven't seen Ben
No, no.
manager filling up forms. I have
I,
seen officials. filling up forms.
I did not take any loan. Far as my ladyship is
I have
talking about
seen,
loan. Your
officials
lordship
filling
has
up
gone
forms.
through the papers. I do not know, but it is a natural call of a bank.
Officials will fill up the
Yes,
forms, but why
he
the
is a-
bank manager?
He is the
Himself-
official.
At that time, he was not a
I don't know, my lord. Then then the DRTA certificate may be cancelled. The direct recovery certificate, because the DRTA is the adjudicating officer.
There you have a point. He has sold a land to that. I am not disagreeing.
I will produce all those documents, my lord, from the DRTA, that how the certificate has been issued.
There are two questions, my lord. DRTA proceeding is different, my lord, and this is a criminal proceeding. my lord. Question is that, my lord, I have submitted some documents.
He is a party to the DRTA proceeding.
with a
He has
view to
submitted
my
himself to a
obtain-
DRTA proceeding.
I submitted some documents with a view to obtain loan, my lord. That documents were misused, my lord, by forging my signature. This is the clear cut, my lord. I am not related to any DRT, my lord. I do not know the person who borrowed the loan, my lord.
Now the
don't
DRTA
know
has
anybody.
issued the notice to take over the land and for sale, auction sale. That is the issue. Let them approve the DRTA. There is a fraud has been committed and DRTA
We
certificate
are
is
concerned
recalled.
of the, we are concerned about the police station case, my lord. And there are sufficient materials, my lord. If required, my lordship may go to the case diary, my lord. I flag my relevant portion, my lord. How he has, my lord, fraudulently, my lord. He has forged
Yeah, I'll need
signature,
some
my
time.
lord.
I'll need some time to go through.
Yes, man. I have strong objection, my lord, in this
I'll
case.
pass an order later. I'll go through the. CD.
My only request, my lord, that this is not a one-way single window to decide. Because the DRTA proceeding also to be we have to submit. The DRTA entire records, my lord. Lordship may,
If your order.
no, not only, it will not satisfy my lords, because the entire proceeding will, lordship is to go through. Because our bank application, the notice, the DRTA entire
You have
order.
annexed the documents, no?
Huh?
You have annexed the
No,
documents.
that DRTA, because the DRTA proceeding, we are not annexed here. We'll produce now.
My lord,
How this investigation is nullified, it will clarify by this, but by that proceeding.
my lordship knows it very well, my lord. When a my lord matter goes to DRT, my lord. Suppose, my lord, I obtain a loan, my lord. The loan was sanctioned against me, my lord. My lord, after sanctioning the loan, my lord, I have to pay the, my lord, EMI, my lord. If I fail to pay the EMI, my lord, then it will be referred to DRT, my lord.
It's okay, but that person has sold the land also, no?
Yes.
He has
It is
sold the
all
mortgage
done-
land.
it
He has
is done-
committed
it
a
is done all
criminal offense.
fraudulently, my lord. It has been done all fraudulently, my lord.
Who? The
Because
informant.
I never, my lord, I never done
No,
anything,
no,
my
no,
lord.
it's okay. See, that, that loan was procured fraudulently by the third party,
Yes.
whoever it
Yes,
is,
my lord.
50 lakhs.
Yes.
He asked for 10 lakhs.
Yes.
And meanwhile, he sold a land.
Yes.
Meanwhile, why did he sell it?
That
Meanwhile,
is,
he
my lord,
sold
that
the
is
land.
his submission, my lord. That is his submission.
Mr. Mission, then the police
That is-
investigation
my
is
lord,
also
that
to be
is-
said to
It
it.
is the submission of the, my lord.
This is the
largest
sale deed is
of the
there.
Petitioner, my lord.
Once I submitted, my lord may record. I cannot say any false statement
My
before
lord,
this honorable
assuming,
court.
my lord, I have sold the land, my
They
lord.
may.
My land, my lord, I can sold it.
How then,
What is the
my
problem, my
lord?
lord?
Now,
I
without
have-
title document, it is admitted that the title document has been deposited.
Deposited for what purpose? my lord? Loan has not
Informant
been sanctioned, my
said
lord.
that the
I have
title,
deposited the loan, I have deposited
is
the
set up
documents
for
for in
auction.
the bank, my lord.
yes.
And who is taking, Rohit Sai who's taking to auction?
No, this auction will by the bank.
No, that land has been auctioned.
Now it's going on process.
My lord, lordship may
And
clearly
therefore
say,
this
my lord,
affair.
assuming, my lord, I have obtained a loan, my lord. If the loan is sanctioned, my lord, after that I have sold the land, that there might be a
Unnecessary
question.
will spoil the time of this.
Then there might be a
honorable court,
question, my lord. I have never, no loan has been sanctioned, my lord.
We will produce the
Without
entire
sanctioning the
document.
loan, my lord, if I
including
sell
the
the
sale
land,
list.
so, my lord.
I understand. No loan has been sanctioned. to
Yes,
you.
then, my lord, where is
But
the
that
question, my
loan
lord?
was, you were turned into a guarantor and the loan was given to Rice Basia. I
Another
understand.
person, my lord, yes.
That is the fraud
And in
committed.
the
allegedly.
meantime, my lord, if I sell my land to somebody else also, my lord, what is the offense, my lord?
Yeah.
Assuming, my lord, what is the
Yes.
offense, my lord?
Yes.
We will give it a date, my lord, or we will produce the documents of the DRT. Because otherwise, That because they also know they without this case diary does not reflect that he has sold out the land. It's a very serious thing. They deposit title this before the bank, and the person knowing the fact that he has no title document in his hand sold the land, which is mortgage land. It's a very serious matter. So we'll produce an entire document.
But then we'll extend and fix a date then.
Yes,
We'll extend the interim
Yes.
hearing.
we need a 1 month time. I will produce.
We'll
For
send
the
back,
four
we'll
one
send
one
back,
one
It
six
is.
cannot- We have to return the case diary.
we'll send it back. We'll send it back. Our learned senior counsel, Mr. B. Doctor, for the petitioner, who has submitted that documents relating to sale of the land. to-
Then they are
documents
relating to
relating
DRT
to,
process.
DRTA proceeding will be submitted through an affidavit.
Yeah, throw an affidavit.
Will be submitted through an affidavit relating to the land in connection with this case. Send back the CD, call for up-to-date CD, list the matter on. Interim order shall remain in force till then.
Item 15, my lord, we have received the case diary, my lord.
Hmm.
And the accused person is on interim, my
Hmm.
lord. So I'll request some instruction, my lord. Can it be taken after a week, my lord? please?
Learned counsel, learned additional PP, Mr. R.J. Borua has submitted for time to obtain some instructions, all right?
My lord,
List the matter on
next week, my lord, on 2030, my lord, 30.
send back the case diary, okay?
So we'll retain, my lord.
Case diary to be retained till
Alright,
Item 16.
interim order shall remain in force till.
my lord.
Sixteen, my lord, also the petitioner on interim, my lord, CD was called for, my lord.
Is there, but the statements are not there, Lordship, so it need to be updated.
CD, you have the CD?
CD, but their statements are not there.
Learned counsel, Mr. S. Chauhan, no?
Yes, Johan.
S. Chauhan has submitted that the petitioners have appeared before the IO. To stop learned result, people, Mr. K. Das has submitted that the CD is not up to date, send back the CD, call for the up to date CD, along with the statements of the petitioners, list the petitioners.
Two petitions.
Petitioners, list the matter of interim order shall remain in force till then.
Item 17.
Your worship, interim is there, my lord, and he has already appeared, and that about that Umrah Hajj, my lord, he is.
Oh, that is misappropriated money.
So, that is,
Ticket.
yes,
Ticket.
so it is not misappropriation, I simply, my lord, I have introduced some person, my lord. I was also willing to go to the Hajj. I also could not call him. So already he appeared, my lord, statement accorded, and your worship, other person already given bail also.
What do you have?
As per his role is concerned, Lordship, it is stated that, Lordship, he has falsely promising false services and collecting funds. He collects money, Lordship, and give it to the main accused, to Islam.
Main accused not yet, yeah.
Rashidul Islam.
As per FIR, accused number 3 is the main person, my lord, as per FIR. I am not 3, my lord.
But his involvement is there, Lordship. Whatever.
Anyway, my lord,
Materials are there.
already appeared, my lord.
Bond is not very heavy.
Yeah.
Bond is not very heavy.
FIR says
7
only,
lakh, 7 lakh something.
No, 7 lakh
no, 1 lakh,
altogether.
altogether,
7 lakh.
7%,
Lot,
7
lot.
lakhs.
It was a heavy. Paragraph 1, 17/3/2025 order, paragraph 1. Paragraph 2 only, paragraph 3. Paragraph 4. Paragraph 5. नाम तो लिखी दिया ना रेशन पीपी नाम तो लिखी दिया पैराग्राफ 5 तो लिखते paragraph 6. Paragraph 7, paragraph 8. I have also scrutinized the case diary. The petitioner has appeared before the IO and he has cooperated with the investigation. It appears it appears that custodial interrogation may not be required as investigation has progressed substantially. Considering all aspects, the interim order dated 17/3/2025 is hereby made absolute under the same terms and conditions.
17/3, in order dated,
17/3/2025.
published.
Possibly little bit accommodation also. Can be day after tomorrow also this accommodation.
Learned Counsel, Mr. A.J. Ramek has prayed for adjournment. You have the CD? List the matter on. CD to be retained here. You have the CD?
FIR in page, my lord, 12, my lord. But I am
The cases because
respectfully beg to state that my husband Amir Hamza Khan as daily routine manner went out from the house on 8/1/25 Wednesday at about 4 p.m. to the river Brahmaputra to catch fish along with net and boat. On the next day morning at about 8 a.m., my daughter, namely Anjuma Khatun, went to Katlamari Ghat of Brahmaputra River to provide milk, but as she did not found her father, she returned home and asked to the other fishermen about her father, but did not get any information. On that day at 11 a.m., one Mazum Ali, fisherman, informed over phone to my father, Jabbar Ali, that he noticed the boat and fishing net of my husband in the riverbank of Brahmaputra without having my husband. Thereafter, my family members searched at different places and communicated with mobile number so and so, but found switch off. I informed to Gondiana police station regarding missing on 9/1/25 as I could not found on searching different places. Though searched for some days but does not found my husband Amir Hamza. Last on 13/1/25, the BSF of Sutlamari BSF camp noticed the dead body of my husband and informed to Bondihana PS as being identified by the family members. After post-mortem, janaza prayer was performed on 14/1/25. Sir, there was a quarrel in between the accused persons and my husband, and they threatened to my husband to kill by life. This is the allegation against us.
Yes, what you
The
have?
circumstances.
regarding the first matter, their evidence part matter, there are specific evidence against them that there is a fight between these two persons and the deceased for purpose of fishing area. And they threatened to kill him if they did not if my lord the deceased did not follow the instruction my lord. That is the case against them. My lord. And so far injuries concerned, my lord, there is no PM. My lord. Injury injuries in the inquest report is there, my lord. The inquest report says there are injuries over his body, my lord. No, you are found running. My lord. The PM is not here. So if you wait for the PM, that is different thing. Otherwise, my lord, without going to the PM, there are some evidence against.
Let us call for the PM report.
My lord, but what happened, my lord? Only one allegation
This is a
without
murder
any.
case. Let us call for the PM report.
That may be called for, my lord. I may be protected.
There are
by the
injuries
court.
according to the
Inquest.
My lord,
report.
whatever may be, my lord, that the entire case only allegation is
Okay,
that
let us call for the PM
there's
report.
a threatening, no death, my lord, and flatly that we are threatening.
It is received without the PM report. Send back the CD, call for the up-to-date CD along with the PM report. This is the matter of 8
But my lord, my only submission, my lord, PM report may be received, injury may be found, but what happened, my lord, only man,
That
man
is
is
for the
died.
trial court to decide. That is for the trial court to
Obliged.
decide.
Item 20.
May I please note? What's its second bail application? Earlier, it was rejected on 12/2/2025. The order is at page 23,
Forest case.
forest case.
Relating to what? Dinosaurs?
Some contaminants, wildlife contaminants.
Okay, tiger nails and all those things.
Some tiger bones.
What do you have?
My-
The CD cannot be updated because the petitioner has not appeared before the authorities yet. It's absconding. And the grounds for rejection in the last order, my lord, those remain, my lord.
Same.
My new ground is regarding some health issues. Our air annexure 6, page 26 and 27.
What is it?
Page 26 is a doctor's prescription dated 3/12/2024.
Mm.
He was suffering some back pain and all, and some medicines were advised to him. And thereafter, he again went to the doctor on the next page 27, 10/3/25.
Mm.
On that day, doctor advised him on the left side advice reference referred to well-equipped hospital to consult with neurologist. And this certificate has been issued by medical officer, business state dispensary. So he is having some medical issues. Therefore, this is the new cause for filing
Where is the FIR?
FIR is a complaint on page 12.
Please read.
Page 12,
Mm.
there are two accused. One is Basudev Roy and is Akshay Mandal. Akshay Mandal is the petitioner. Basudev Roy was arrested and he was granted bail subsequently. Paragraph number 1. The complainant is an officer rank of Forester 1 and discharging as IC Kuklung Range, Kuklung under Manos Tiger Reserve. Next page. That after getting an input from reliable source, a raid was conducted jointly by a team of Kuklung, Panbari and Basbari Range in the house of the accused, number 1, on 7/12/2024 at night about 7:30 p.m., where the suspected materials of wildcat species were found, which were about to sell. The complainant begs to state that immediately the materials were seized at the spot at about 7:45 p.m. from the custody of the accused number 1, that Basudev Roy. Being the situation not favorable, the forest team immediately left the spot and reached Panbari Range, detaining the accused number 1 along with seized material. The complainant begs to state that the Panbari Range office, the seizure list was prepared at about 9 p.m. The accused was duly interrogated, where revealed the fact of accused number 2.
Okay. So there is evidence according to you against accused number 2.
Yes, and he has not appeared also, my lord. And my lord,
Due to his apprehension, he is not appeared. And the new facts regarding his medical condition. So on medical condition, he may be granted bail. Then he will appear and he will
What
cooperate.
is the punishment?
3 years.
punishment is, my lord, now 7 years post amendment. Minimum is 7 months. Goes up to life in prison.
Okay, you have any objection?
Objection is there, my lord.
Medical
It involves
condition.
either
On
leopard
medical
or
ground.
parts of leopard or tiger, man. That is the wildcat means either leopard or tiger. Forensic and analysis
Serious
is
offense. I understand.
that
Serious.
is why I saw.
But on medical ground,
Medical, my lord, he's a 31-year-old, my lord, person.
One thing is that only allegation the accused number 1 has made allegation thing in thing. And
And-
another thing is that he is a permanent resident of the
no, they are,
Chiang district.
they are dealing with all this, no doubt about it. But just I'm thinking about considering on the medical ground.
On the medical ground, he may be allowed and he will cooperate. And any condition may be imposed that he will appear and any condition.
But I think he's not very serious.
Actually, he has been maybe the certificate has been issued to consult the neurologist of well-equipped hospital, and this has been issued by the medical officer also, so by government medical officer, state dispensary. So only on those grounds may be considered. Any condition may be imposed.
That means he has killed the tiger.
Could be, my lord, but he will have to be in Custody, my
Only
lord.
contraband has been
Only-
recovered.
In custody, my lord, the full fact can be.
He will cooperate, Lordship.
And my lord, this, my lord, new ground, my lord, this may not be considered as a new ground, man.
Medical condition.
Yes, my.
On medical ground, and he will cooperate, any condition may be imposed.
10/3/2025.
Earlier also on 312,
That is not new ground, but now it's a new ground, I think, 10/3/2025.
Thank you, my lord, merely a prescription, but it's not even admitted or.
for admission, he has been referred to consult well-equipped hospital.
You have the CD, offense report or CD, whatever it
My
is
lord,
called?
the offense report annex here, my lord, that is the latest one. Besides that, if the petitioner is interrogated, then only, my lord, this updated CD can be made, my lord. Otherwise. New materials, my lord, can.
See, this is not a, this is a
I
referral,
understand, but only on medical.
not a medical, no, this is a referral, not a medical certificate. So if we find something cogent against him, then we will reject the bail,
Okay, definitely.
okay? On that ground, we'll grant him bail. We find something cogent against him, then you cannot raise objection like
If he
the
is, my
previous
lord,
bail. petition.
if he is charge sheeted, my lord, then it can be cancelled.
Hmm?
If a charge is made against him, then it can be cancelled, my lord.
Hmm. On medical ground, then, heard learned counsel, Mr.
D. Chaudhary.
B. Chaudhary for the petitioner. Oxford Model, who has filed this application under section 482 of the BNSS 2023 with way of pre-arrest bail as is apprehending arrest in connection with so and so PS case under so and so sections. Heard learned counsel, Mr.
I bought a
I. Bothakur for special PP forest,
wildlife, but
for special PP wildlife. Who has raised serious objections against the bail petition stating that the petitioner is equally responsible in connection with this offense. It is submitted on behalf, next paragraph, it is submitted on behalf of the petitioner that the petitioner has been, the petitioner is not directly involved in the alleged, with the alleged offense. Full stop. The objectionable articles of objectionable body parts of wildcat was found with the first, with the accused number one, Basudev Ray, who was already, who has already been enlarged on bail. Full stop. The petitioner was not aware that these were smuggled articles and in contravention of the Wildlife Protection Act, these articles were procured by petitioner number one. Full stop. The petitioner number, or the petitioner has approached this court under change of circumstance, as his earlier bail petition has been rejected. It is submitted that the petitioner petitioner is suffering from neurological problem, and annexure
6.
6 and annexure 6 of the petition are the documents in to substantiate that the petitioner is ill and he has been referred to a well-equipped hospital to consult with a neurologist. Full stop. The petitioner is also willing to cooperate with the remaining part of the investigation. Full stop. I have considered the submissions at the bar with circumspection. I have also considered the ailment of the petitioner. The petitioner, petition is hereby allowed in the event of this address, the petitioner shall be. So this is absolute, we'll have to make it absolute.
But
We have the offense report, no?
But he has not appeared yet, my lord. So if some strong material is found against him,
Then, my lord, if he's not in custody, then my lord, the case may be hampered.
He will appear and he will record his statement.
Okay, then we, that offense report has to be updated. Or what
It
is
has to
called?
be updated, my lord.
CD.
This is not final.
It is submitted on behalf of the petitioner, or it is submitted by the learned on behalf of the forest
Special PP wildlife.
or special PP wildlife that investigation is still under progress and the case diary
Needs to be updated.
is required to be updated. It appears that interim petition is allowed to continue. It appears that interim bail may be granted to the petitioner. Call for the updated case diary. In the interim and in the event of his arrest, the petitioner shall be enlarged on bail of rupees 50,000 with a suitable surety of like amount to the satisfaction of the arresting authority. Under the condition that the petitioner shall appear before the IO within 1 week, IO, no? IO within 1 week and cooperate with the investigation. Number two, the petitioner shall refrain from such activities with which he is alleged. And the petitioner shall not leave, okay, he has to go for treatment, no?
Yes.
On breach of any of the bail conditions, bail order shall stand automatically cancelled.
Much obliged.
Problem.
21 to 1. Or do the
CD,
we have the CD.
My lord, FIR is page 9.
But one thing is there, Lordship, one affidavit has been there in the CD, given by the.
Informant. She realized that she mistakenly mentioned their name.
Yes, it is.
Mentioned their name. Actually, there is a mob, my lord, public gathering is there.
FIR is at page 9.
Right.
Okay, then. Our
On the
learned
ground
counsel,
of that.
Hmm?
On the ground of that affidavit.
yes, yes. Our learned counsel, Mr. J. Ahmed, no?
Yes, my lord.
For the petitioner. Yusuf Sheikh alias Assault petitioner, Saijan.
5 petitions,
5 জন, no?
5 persons.
1, 2, 3, 4, 5. Who have filed his application under section 482 of the BNWS 2023 with prayer for pre-arrest bail as they are apprehending arrest in connection with so and so PS case under so and so sections. Heard Mr. K.K. Das, learned additional PP Assam. The allegation against the petitioners is that they have vandalized and ransacked the informant's house and also looted from her house and set
Fire.
and set ablaze the informant's house, causing thereby causing mischief to a great extent. I have scrutinized the case diary. An affidavit is also found in the case diary relating to misunderstanding which resulted in the FIR. It appears that pre-arrest bail may be granted to the petitioners. The petition, considering all aspects, the petitioners, the prayer for pre-arrest bail is allowed. In the event of the arrest, the petitioner shall be enlarged on bail of rupees 30,000 with a suitable surety of like amount to the satisfaction of the arresting authority under the condition that the petitioner shall appear before the IO within 1 week and cooperate with the investigation. The petitioner shall refrain from such activities with which they are alleged, and the petitioner shall not exercise threats to the witnesses on breach of 30,000 each. On breach of any of the bail conditions, bail order shall stand automatically cancelled. Send back the CD.
Hello.
Item 23.
CD is not received, we need the CD.
Next week, 30th April.
CD is called for is not received, we should reminder list the matter on next week meeting.
Like, not period
We have
bail
the CD.
application, my lord. FIR, my lord, is at page number 16.
Mm.
Basically, my lord, it started with a fight between, my lord, children of Rohima and Rofika, my lord. There was a fight between, my lord, the children while they were playing, my lord, and that spread to their parents.
FIR is at page number
Page number
16.
16.
Agomoni PS case number 44, 2015.
Yes.
Huh?
Yes. So,
Please read.
my lord,
Please read.
yes. সন্মানপূর্বক বিনীত নিবেদন এই যে আজি 9-3-2025 তাৰিখে সন্ধিয়া অনুমান 6 মান বজাত নিম্নলিখিত পদকীয়া গণৰ 1 নম্বৰ
About a victim visit was done by the PM examination visit was conducted. And the PM says, my lord, in my opinion, cause of death is due to shock and humerus as a result of head injury caused by high velocity impact of hard object following physical shock, which is antemortem in nature. So this petitioner is also directly involved in assaulting the deceased person. my lord. Secondly, you will also be found the next part you're doing investigate iron sword with blood stain across 24 cm is legs with gun handle. Hair sample suspected to be victim of disease. Blood sample and cotton of disease were seized and sent all the items to FSL. And now, FSL report. What I like to submit, that all these petitioners or three petitioners, three accused along with this petitioner, they are directly assaulting the victim, which resulted in the thing. This is come out from the 162 statements of the victim. And you'll also will find, my lord, the 180 statements, I have flag marked, my lord, in the. And PM also, my lord, I have correlated, there are also injuries are there as prescribed.
My lord, all I want to say, my lord, this is 164 statement. This is subject to trial. And look at this statement, my lord. My learned friend has already read that he hit with a big bamboo. 81-year-old man. Is that even possible? Can he raise that big bamboo? 81-year-old man is not believable, my lord. Subject to trial, I have surrendered, my lord. 53 days in detention. The trial is not going ahead, my lord. What purpose will it serve, my lord? And there, your lordship has already granted bail to the other co-accused. My lord, I would like to take your lordship through page number in the forwarding report, my lord. This is page number 18, my lord. Page number 18.
Why would they implicate this old person? They have implicated him.
My lord,
Witnesses.
this arises from the family dispute, my lord.
Why this old person? What vice they have against him? Such an old person.
My lord, that is subject to trial that I am not involved here, my lord. But I am,
What do you want me to check? Which
my lord,
page?
page number 18, my lord. Page number 18 is bail objection. The accused person may not be released on bail to prevent such person from committing any further case for proper investigation of the case. My lord, already on the same day, my lord, charge sheet has been filed on the same day to prevent such person from causing evidence of the case to disappear or tampering with such evidence in any manner. Again, my lord, 81-year-old man and the other co-accused has been released on bail. Your lordship has released them on bail. My lord, how can this person tamper with the evidence, my lord? And I have surrendered, my lord, 53 days in detention. And plus, I have already submitted, my lord, that the presiding judge, my lord, the honorable judge has been transferred and there has not been appointment of a new judge. So trial is not going forward, my lord. So I may be released, my lord. I have surrendered, my lord, on the same day charge sheet has been filed and then in detention for last 53 days.
And the next or order in the correct is.
He caused the fatal injury. He has caused the fatal injury.
My lord,
This person has caused the fatal injury. Bahut Quran and Mura, something like that. That head injury.
Yeah.
yes, my
He has caused the fatal injury.
lord, that is 164 statement, my lord. So the informant will obviously
No,
give a
there-
statement
not
against
only
me, my lord.
informant, there are many witnesses.
My lord,
Not
that is
the informant, there are many stay with statements, 164 statements of several witnesses.
My lord, that is, my lord, subject to trial, my lord. Subject to trial, I will participate in that trial. That's why, my lord, I have surrendered, my lord. Considering my age, my lord, 81-year-old person, my lord.
It's quite a threat.
My lord, 81-year-old.
80 years, I don't know.
This is not believable, my lord. Raising a big bamboo and hitting on the head. This is not believable, my lord. The trial will reveal the truth, my lord. Any condition, my lord, I am already there, my lord, inside. I have surrendered, my lord. There is a bail order where your lordship has
Three
granted
of
bail.
them together led by him.
My lord,
Three have done them together led by him. Attack this poor person who was alone.
my lord, these are mere allegations, my lord. These are mere allegations which are subject to trial, my lord.
But he has died, no?
He has died. Unfortunately, he has died, my lord. They are within the same family. There is a land dispute, my lord. There is no denying, my lord, that the person has died, my lord. This is a very unfortunate incident. But this petitioner is not responsible for it.
He is the one who led the team
That's a mere allegation, my lord.
and he dealt a fatal blow.
My lord, considering his age and length of detention, my lord, I may be released, my lord. That is my respectful submission.
I think he can very well look after himself in the jail.
My lord may consider me. Had he been a young person or even below 60, my lord, I would not praise this. 81-year-old man and surrendered himself, my lord.
In case of matters, I am in a dilemma now. 80 years old, but is behaving like 20 years old.
At this stage, my lord, he should have matured enough to stop the fight, my lord.
Yes,
Instead,
is participating. Instead. And his picture. Oh, this is another person.
Raising a big bamboo man, prima facie is not believable, my lord, by an 81-year-old man. The charge sheet itself, my lord, that contradicts the reality, my lord.
You see, we have the corpus delicti.
My lord, there are other accused also, my lord, who has done this, my lord. When your lordship has released them on bail. Any condition, my lord, any condition, I will participate in that trial.
I'm trying.
Madam.
I'm going through the records. Let me see. Trying. Hesitantly, I'm trying.
I am grateful, my lord.
Beforehand, I didn't pass an order. Beforehand, you are grateful. You have the PM report, no?
PM report, yes, just like.
Not sharp weapon that has caused the death, it's the blunt weapon that has caused the death.
Yes.
And the weapon was used by this person.
My lord, I have made categorical statement, my lord, in para 16, that as the patriarch of the family, he tried to intervene. He did not hit, my lord.
No,
Shock and hemorrhage
I'll read it out.
heat injury.
Due to shock and hemorrhage as a result of head injury
Head
caused
injury.
by high velocity impact of hard object.
Heart attack. Not by me, my lord. I am not denying, my lord, I am not denying that the person has not been hit. He is dead, my lord. The act has been committed by the other accused person. I tried to intervene, my lord, as the eldest person of the family, my lord. And apart from that, my lord, I surrendered before the learned trial court, and it's already 53 days in. Keeping me behind the bar is not serving any purpose, my lord. When the other co-accused is also released on bail, I will participate in the trial, my lord.
Where are the bail orders of the other co-accused?
My lord,
Because their blows didn't kill him.
my lord,
Their blows didn't kill him.
but even my blows didn't kill him, my lord. It's quite natural, my lord, as an 81-year-old person, I cannot raise a heavy bamboo, my lord. And I cannot hit with a blow, my lord, that the person will die.
This is which page is the order where I've granted bail?
My lord, we have not annexed that, but I period of detention before the search.
Okay. 180 days. Oh,
No,
90
no.
days.
Date is not specified. I think it was before 90 days they were released. Before 90 days. It was not a statutory review.
Condemn bail.
Statutory. Date to be, date to be. Next week. Date 48.
Learned Counsel, Mr. A.W. Awan, no?
Aman.
For the petitioner. So Mohammed Sonauddin Sheikh alias Sonuddin, who has filed this application under section 483 of the BNWS 2023 with prayer for bail as is behind bars since 28/2/2025 in connection with
Pusega PS case number 84/2020.
second case number P-1. What is the sessions case number?
My lord, the PRC number 3225.
We have a sessions case number of.
No, he was arrested. The charge sheet was filed after his arrest.
PRC case number sessions case
PRC case number 32/2025.
arising out of so and so PS case under so and so sections. Heard Mr. MP Goswami, learned additional PP Assam, who has raised serious objection against the bill, stating that that at this stage of trial, the petitioner is not entitled to bail. Full stop. The trial may be adversely affected if the petitioner is enlarged on bail, considering the gravity of the offense and the allegations against him. Full stop. Charge sheet has been laid against him as the petitioner is complicit. Full stop. The learned counsel for a petitioner has submitted that the petitioner is 81 years old and it is not plausible that he is involved in such a heinous offense. Full stop. Due to a family dispute between both the parties, the allegation against the false allegations have been made against the petitioner. Full stop. I have considered the submissions at the bar with circumspection. Full stop. This is a charge sheeted case. And and indeed a prima facie case has been found against the petitioner, which led the IO to submit charge sheet against him. Full stop. I have considered the age of the petitioner. Full stop. I have also considered the fact that the petitioner is willing to cooperate with the trial. Stop. It appears that bail may be granted to the petitioner. First off, the petitioner has also paid for bail on the grounds of parity as the co-accused Mufizul Haq and Anwar Hussain have already been granted bail in connection with high order dated 14/8/2024 in connection with BA number 2312 of 2024. The petitioner is enlarged on bail of rupees 50,000 with a suitable surety of like amount to the satisfaction of the trial court.
My lord.
Or CJMT, to the satisfaction of the trial court.
My lord.
Under the condition that the petitioner shall.
Trial court
not-
judge has been transferred, my lord.
No, somebody will be in charge, they'll take the acceptance
My lord, my lord.
to the satisfaction of the trial court, no? Under the condition that the petitioner shall not leave the, where will he go also at this age? Not leave the jurisdiction of the court without till completion of the trial. To stop, and the petitioner shall refrain not exercise threats to witnesses.
Grateful, my lord.
May it please, Your Honor. This is a regular bail, my lord. Yeah, my lord, the FIR your lordship will find at page 12, my lord. Smaller.
Yes.
May I read, my lord? With due respect, I beg to inform you that today on so and so, the following mentioned two accused persons have suddenly entered into my rented room while I was coming.
These are maximum punishable with 7 years. And in this case, no 41 and notice was issued. And for the reason that also not mentioned in the forwarding report.
LGTPS case number, what is LGT? Lahori?
Lahori.
Lahori
Lahori.
PS case number C.
Yes.
58 of 25.
25.
Yes, what do you have? CD?
CD not received, my lord.
Or CD is not received?
My
What
lordship
is it?
has stated case.
No, this is first day.
First day.
And already.
Motion?
No,
my
hearing,
lord,
bail hearing.
it was listed last on 11/4, my lord.
Bail hearing.
Yes, on first day also I have submitted that 41 a
You
notice.
want a
was
CD?
From
not-
my lord,
This is Page 9.
Lahori.
Because the girl, the informant lordship, his lordship was having.
Sorry, Lordship, at page 16, your Lordship will find the FIR.
Fire. Page 16?
Page 16 is the vernacular, Lordship.
Okay,
May I read the FIR, Lordship?
yes.
There are two accused persons in the FIR, Lordship. FIR named accused number 2 is before your Lordship. সন্মান সহকাৰে আপোনাক জনাও যে 10/1/2025 তাৰিখে মই কিছুমান মাল্টিপল কনসাইনমেন্ট লাইক গ্ৰসাৰী এণ্ড প্লাষ্টিক আইটেমছ এণ্ড চিগাৰেট শিলচৰৰ পৰা ক্ৰয় কৰোঁ আৰু নগাঁৱত বেচিবলৈ এখন বলেৰো বাহন হেভিং ৰেজিষ্টাৰ্ড নম্বৰ so উপৰোক্ত 2 নং পদকীয়া ড্ৰাইভাৰৰ জৰিয়তে আনো যোৱা 11/1/2025 তাৰিখে ৰাতিপুৱা প্ৰায় 6:30 মান বজাত 30 ৰ পৰা 7:30 মান বজাত উপৰোক্ত 1 নং পদকীয়া আৰু 2 নং পদকীয়াই মিলি মোৰ মাল অনা গাড়ীখন অভিখণ্ডি কৰি খেৰণী কোনো এক ঠাইত লুকুৱাই দিয়ে মই বহুত খোজ বিচাৰ কৰি যদিও আজি পৰ্যন্ত তাৰ কোনো ধৰণৰ সংসূত্ৰ বিচাৰি পোৱা নাই so initially so as part of the FIR Lordship am I audible Lordship?
Misappropriated the
Articles, my lord.
articles.
That was used for transporting.
What has this got to do with it?
Lordship, his marriage is fixed today Lordship.
Today is his marriage.
Yes Lordship.
Okay.
Fa-
Who, that accused persons?
Yes Lordship, the accused person. The petitioner, FIR named accused person, he has already been granted bail by the learned Court of Session Judge. However, in respect of petitioner number, present petitioner, his bail was rejected, Lordship. He had preferred a bail petition,
He's
your
not
Lordship.
an FIR named accused, Uttam Juti Nath.
Yes,
He
Lordship.
is an
Uttam
FIR,
Gupta.
two accused are there, my lord.
Okay.
One His,
One
like,
Uttam day, okay, okay. accused
one
of
is,
what-
Uttam
one
Day
is
has
granted.
already been granted bail.
One is granted, he's, my lord, rejected.
He had preferred a bail petition that was subsequently rejected by an order dated 5/3/2025. The relevant portion of the order your lordship will find at page 18.
Okay.
Page 18, lordship.
Hmm.
May I read, lordship? Page 18. The relevant portion, the IO has submitted an objection petition stating that both the accused persons are named accused and they are evading from police arrest. That notice under section 35(3) of BNSS was issued to accused Uttam Dey for appearing before him on 25/1/2025, but he is not cooperating with IO till date. That if the accused persons are released on bail at this instant, there is no possibility that they will cooperate with the IO, etc. in raised objection. On going through the CD, it appears that IO issued notice to accused Uttam Dey under section 35(3) of BNSS directing to appear before Khairani police station on 21/1/2025. And in the CD, it also appears that accused Uttam Dey duly appeared before IO on 21/2025. And his statement has already been recorded by the IO. So the objection submitted by the IO in respect of accused Uttam Dey is found baseless, and such kind of objection does not carry any value in the eye of law to consider bail application. On going through the entire CD, it appears that another accused, Uttam Jyoti Nath, has not appeared before the IO. The learned additional PP submitted that there is sufficient materials against the accused, Uttam Jyoti Nath, and if he is allowed to go on pre-arrest bail, the proper investigation may be hampered. On perusal of the CD, it also appears that there is incriminating materials against the accused, Uttam Jyoti Nath, and police has failed to arrest him till date. So the bail application was partly allowed in respect of the present petitioner, that was rejected. Now, Lordship, a perusal of the order passed by the learned sessions as no way shows that notice under section 35(3) was issued to the present petitioner so as to enable him to appear before the investigating officer to record his statement. Notice was issued to the FIR named accused number 1. In terms of that notice, he appeared and his statement was recorded. There was no notice issued, so therefore there was no occasion for this petitioner to appear before the investigating
This is
officer.
a bail hearing. Do you have
This is a
to-
bail hearing, my lord, the CD is
Have
before
they
us, the CD is before us, my lord. As per your lordship has seen the, my learned trial court order, my lord. Another person's bail is granted because there is,
Notice
there is
was
no
issued
materials
against him when he has
against him.
appeared.
And against him, my lord, he is the person who took the consignment, and thereafter, after going, he switched off the mobile phone, and thereafter the vehicle that is found is in empty condition, and all the articles are misappropriated. That is the case against him now while he is on the absconding.
Articles have not been seized during.
No, the vehicle was seized, but without the article.
Without the articles.
The vehicle was seized, the vehicle has already been released to the original owner, Lordship.
But the articles, they are, they're.
Lordship, these articles, in respect of the articles, Lordship, your Lordship may kindly see page 4 of my petition, Lordship. I have annexed one invoice which is issued by the Dimahasa Anti-Tax Gate at Mandardisa. The complainant, he himself booked this Bolero vehicle, and then he himself went along with the petitioner and loaded 10-15 cartons of consignments, some cigarettes. And therefore, at page 20, while crossing Mandardisa, Dimahasa Autonomous Council, one tax invoice was issued. And while returning to Guwahati, the complainant himself asked him to unload the curtains at Sonapur. In fact, toll tax were deducted for the vehicle, Lordship, at Roha as well as at Mikirhati toll gate. So there is no question of unloading or stealing the consignments at Khairani, Lordship. And in fact, on 12/1, he was taken to the complainant and his friends. They took him to the Khairani police station. At page 21, I have annexed a medical certificate, which the petitioner could somehow clicked on his phone. Though there is no date mentioned, in fact, he was taken to
Kherani police station. He was slightly beaten up, and then the doctor advised him to apply ice on on those injuries. So, Your Lordship, since his marriage is fixed today, Your Lordship may kindly be considerate enough, kind enough to consider his bail, Lordship, because his marriage is fixed today, Lordship. And it's a case of theft. And had there been any notice issued, he would have surely and certainly appeared before the investigating officer to record his statement.
On the ground of marriage,
Interim or
interim.
if your lordships allowing.
Yes,
But we-
Lordship may
Marriage.
kindly.
But we had the CD also.
Yes.
No? Can. Third learned counsel, Mr.
Our Bora, Lordship.
R. Bora for the petitioner, Uttam Jyoti Nath, who has filed his application under section 482 of the BNWS 2023 with prayer for free arrest bail as is apprehending arrest in connection with so-and-so PS case under so-and-so sections. Third, Mr. MP Goswami learned edition 50 Assam, who has raised objection against the petition, against the bail petition. It is submitted that they are incriminating materials in the case diary against the petitioner. Full stop. The allegation against the petitioner is that he, along with the co-accused, have misappropriated some articles which were sent through the vehicle bearing registration number
AS 23 CC 3544.
AS 23 double C 3544. Full stop. It is submitted that the informant traveled along with the petitioner
Yes, Lordship.
up to which place?
Up to Sonapur,
Up to Sonapur. It is further submitted that the vehicle which has been found missing has already been seized in connection with this case. Full stop. The articles are, however, missing. Full stop. The petitioner has submitted that he has not misappropriated the articles from the vehicle. Full stop. The co-accused has already been enlarged on bail. The co-accused is on the same footing, but as notice has been issued against him, he would appear before the IO. Post of the complainant has not appeared before the IO, as notice has not been issued against, or the complainant or the petitioner has not appeared before the IO, as notice has not been issued against him. Post of the petitioner is willing to cooperate with the remaining part of the investigation. Post of the petitioner's marriage is to be solemnized today. Post of the marriage invitation card has been submitted by the petitioner, submitted on behalf of the petitioner. Full stop. I have considered the submission that the petitioner is willing to cooperate with the remaining part of the investigation. Full stop. I have also considered the submission that the petitioner's marriage is to be solemnized today. Full stop. Considering all aspects, petition is allowed in the event of his arrest. The petitioner is enlarged. The petitioner is to be enlarged on bail of rupees 30,000 with a suitable surety of like amount to the satisfaction of the arresting authority under the condition that the petitioner shall appear before the IO within 1 week and cooperate with the investigation. Okay, within 1 week, immediately after your marriage.
Lordship.
The petitioner shall appear before the IO on every fortnight till completion of investigation, and the petitioner shall not leave the jurisdiction of the court without prior permission, without prior permission. On breach of any of the bail conditions, bail order shall stand automatically cancelled. Send back the CD.
Lordship, the difficulty regarding the permission is that the case is registered at Kheroni, West Karbi Anglong, and he's a resident of Nagaon, Lordship.
Okay, it's all right. We have deleted it.
Lordship.
Yes,
Much obliged, Lordship. Much obliged.
yes. You can,
Thinking that my.
we'll take up your matter on priority basis.
Anyway, otherwise also I think. I can.
You're sitting since morning.
Yes.
I have seen you.
I was not going outside. I have been heard that something will happen, my. So I'm sitting inside my. This case, my lord, that case, that in a school, my lord, that one boy was, my lord, group class was, that one boy was killed, my lord. Item 30. And here, my lord, actually, these petitioners, your lordship, three petitioners before lordship, my lord. Your lordship will find FIR is page. Yes,
Oh,
page 9. That, but your lordship, will-
yes, I know.
yes,
I know
my lord.
this.
Your lordship is. Now, your lordship, these petitioners, your lordship will find, I just did your lordship page 9. I'm just page 9, my lord. The petition of federal petition number 1, 2, 3, my lord. 3, 4, and 6. Present petitioners.
One.
No, 1 already, my lord. 1, 2 already, I think they have been arrested. 5 already got bail. And present petitioner is your lordship will find. Yeah. Yes, Saidur Rahman alias Said Ali. 3.
3 years.
Accused number 3. Then your lordship will find Bahar Ali.
4.
Bahar Ali 4. Then you have Sadiqul Islam
6.
6. Now both 3 and 4, petitioner 1 and 2 are own brothers. And number 3
Petitioner 1 and 2 are brothers.
brothers. And number 3 is the son of number 1.
Oh.
Now the main major problem is with this Abdul Razak. We are the brother of Abdul Razak and that Abdul Razak Maida. Whole Maida, that is the whole dispute centering around the Abdul Razak. Abdul Razak was the president of Maida school managing committee. And the schools Maida, some groups, classes were going on. Ultimately, Abdul Razak also filed a case, cross case, Maida. We are the brother of Abdul Razak. We have no direct education, is not against us, Maida. And your lordship will find Abdul Razak case is page 24. Page 24. This is Abdul Razak. That is accused number 2, my lord. He is my brother, my lord. He filed the case long back, 23, my lord. 3rd December 23. And this person, sir, my lord, all the persons are my lord, that year. The deceased is also, my lord, he is one of the accused in this case. And your lordship will find paragraph page 26. Paragraph 3, my lord. The freshman social was going on that a group of persons, there some class, my lord, and he was that on author principal of the so-and-so higher secondary school, namely Surab Ali Ahmad, made a phone call to me using his mobile number to my mobile number, requested me to go to the school for signing few checks. So-and-so, the Abu Bakr Siddiq also made a phone call to me and also requested me to go to the school for signing. It is pertinent to mention here that from the few days, the principal and the other staff of the school are continuously requesting me to go to the school for signing the check. That in response to the request of the principal, namely so-and-so, 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 I went to the school today, 18 November 23. At so-and-so, and after signing the checks, I was sitting in the office room of the principal, and while I was sitting, I found that the accused persons fully equipped with dangerous and sharp weapons. I was called my door, and there they have the other side have attacked us. That Abdul Razak. We are not there, my lord. We are not there. I further beg to state the accused person name came in their companions, namely Rashidul Islam, Bahar Ali, Iqbal Hussain, Rakibul Hussain, then Hamidul Islam, Hafizul, Taizul, and Rahul Amin, and all joined the accused persons and actively took part in the illegal acts of the accused person and the entire incident, so and so, so and so. So this case is filed on my 23, 18/11/23. And present occurrence, my your lordship will find present
24.
page 9.
After 1 year.
After 1 year. So that way, my ultimately with my brother, there is a conflict, my lord. I am not denying. But so far we are concerned, present to petition number 1 and 2, they are the owner of the restaurants. They are not at all, they are not connected at all, my lord. And number 3, petition number 3 is the son of that year, he is a student of the Madrasa, my lord. And already part charge sheet already filed. Part charge sheet. Part you also want to pay 16. In the part sheet, my lord, they have been shown absconded. 4 person arrested. Page 16, your lordship will find. Part charge sheet, and your lordship will find page 22. Page 22 bottom, your lordship, page 22 bottom.
Yes, yes.
My lord, Roman 11, my lord, 10, 11. my lord.
Yes, yes.
The final postmortem examination report of the deceased has not been obtained yet. So thereafter, during the investigation, there was found sufficient evidence against the arrested accused person so and so. Then from the above fact, a prima facie case found well established against the aforesaid accused person, Rakibul Hussain, Abdul Razak, Mahmudul Hassan, Homogali, under section so and so. Hence, I do submit the charge sheet of the case against the aforesaid accused person under subsection law to prosecute them in the honorable court. Further, it will be mentioned that supplementary charge sheet will be submitted as per provision of section so and so after receiving the final postmortem examination. So only thing even postmortem examination, the rest already over. Everything is over, madam. So on that ground, madam, there is no specific allegation against me, madam. So I think, madam, because they are not directly anything against them, madam. So that's why, madam, I think almost all other persons are already by regular bail or something.
Your Lordship, I have seen that one of the witness have name, direct implication is there against Baharul al-Islam. That is Baharul Ali Lordship. Others I have not seen Lordship name, but the thing is that they have said that these two persons, one is Rakibul Hussain.
Yes, sir. I, number one.
Person Abdul Razak. Their implications are there.
Who is the advocate here? There's one advocate also, no?
Advocate means?
There's one advocate also in this case, no?
Yes, no, he already might have, yes. Huh? Oh, that here, yeah, that is not here in there. This case here, Udon Madad, I think, to try their court below. I do not know what happened, my.
Baharul Ali name is there. One of the witnesses have seen Lordship. And others were masked. Their faces are
Not I
masked.
think so. Already investigation complete, madam. On that ground, I think your lordship, main person already arrested. They already. Yes,
I'll
yes.
check because this is murder case and AB, I'll check. I'll go to the record.
Your
Lordship,
lordship,
it will be good.
something maybe they are arrested, but two that other day also your lordship stated, mind of that. But that with the
But
custody,
according to you, only you have seen Baharul's.
Baharul's name. Other two person I have not.
Not-
seen.
yes, other day
Lordship
also.
may look into it, Lordship.
Okay, I'll check.
I have
Baharul Islam.
implicated Lordship. Where his name is there, I have implicated Lordship. Flag mark is there,
Okay.
Lordship.
So far, Bahagul is concerned, my lord, investigation already complete, only postmortem report remains, fine. That is why I'm saying, man.
Charge has been submitted.
Yeah, part charge submitted and main supplementary charge sheet only after receiving the postmortem report.
But one thing is there, Lordship, one thing is there, however, in page 22, in Peran, point number 10, it is stated that in the course of investigation, also searching other accused persons mentioned in the affair, but they have been absconding his
Yes.
residence as well as location.
Charge sheet they have been sorted. And one of the absconding already got paid by the coordination bench, right?
I'll leave it to Lordship, but in Baharul Ali's name is implicated, Lord.
Obliged to.
Obliged.
Here is a case, my lord. I am a boy of 23 years, and married ladies after me, my lord.
Incarceration. As because, my lord.
How long you been behind
Okay,
doors?
my lord, I was arrested on 21/11/22. I was arrested on 21/11/22
How many witnesses? have
and a charge sheet was filed on 18/5/23.
How many witnesses? have come?
But out of 11, 3 witnesses have been examined. I have given the synopsis, my lord. Writing.
Okay.
Well, that's there, my lord. And my lord, the prolonged incarceration, my lord, the case law I have, my lord, given also there, my lord. Lordship, may kindly take up the case number serial 5, my lord. That Ravi Prakash, my lord.
Yes, yes.
My lord, there, my lord, the next page, my lord, page 2, my lord, paragraph 5, my lord. My lord, because my learned friend, my lord, will take that submission because the petitioner belongs to some other state, my lord. So 5, my lord, sir, 5 it says, my lord, however, we find some merit in the contention of the learned counsel for the respondent state that the petitioner being not a resident of the state of Orissa, some stringent conditions are required to be imposed upon him. That much, my lord. Because, my lord, I am behind the bar, my lord, almost, my lord, almost 882 days. And that is one submission, my lord. And the second submission, my lord, so far, my lord, lordship may kindly turn to page 31, my lord, of my petition, my lord.
Page 31, yes.
Page 29A, my lord, 29A, annexure 2, my lord. 29A, my lord, is a handwritten, my lord.
Hmm.
Lordship got it.
Yes, yes.
Notice under section 50 CRPC, my lord. Lordship, we see, my lord, that the grounds of arrest were not communicated to the petitioner.
Okay.
Well, that too, my lord, and in this regard, my lord, I have also, my lord,
Rian Kumar.
Vinay Kumar, and one of the latest judgments of our court. Vihan Kumar and Probir Purkasta I have annexed, my lord. My lord, that limited submission, my lord. That much,
All right.
nothing to submit, my lord, more. Because I have annexed all those, my lord.
Yes.
Lordship, first, with regard to long inclination.
My lord, can I, my lord, with lordship permission, can I, my lord,
Yes, yes, yes. Of
my
course.
friend will.
Yes.
Lordship, my objection may kindly be stated.
What is the contraband recovered?
Heroin, my lord.
Uh,
Heroin, my lord. I have written there, my lord. 792.35. Second star, my lord.
792.35.
35 grams of suspect.
Yes, yes.
Lordship, here, the dates given by the my learned friend is correct. Lordship, may please to see paragraph 8, 7 of my objection, page 86.
Yes.
Married.
Hmm.
Paragraph 7, page 86.
Paragraph 7,
Paragraph 7,
page 56,
86.
86.
86.
Okay, okay. I was checking page 56, 86. Okay. Page 86. Yes.
Married.
Hmm.
It is learned that the our junior council, standing council, that after filing the complaint on 18/5/2023, the case was received by the Court of the Additional District and Session Judge (FPC) and the Honorable Court on 26/5/2023, who cognizance against the accused persons infraction so and so and fixed the matter on 10/6/2023 for physical protection and copy. Thereafter, on 10/6/2023, a copy was furnished to the accused person in accordance to section 207 of CRPC, and the matter was fixed on 23/6/2023 for consideration of charge. On 23/6/2023, no advocate represented the accused persons, and the accused persons submitted before the court that they did not need any LADC and will engage their own sets of counsel to defend the case. So the court again fixed the matter on 7/7/2023 for consideration of charge. On 7/7/23, no counsel represent the accused persons, and the matter was again fixed on 21/7/23 for hearing of the charge. On 21/7/2023, the counsel for the accused persons sought an adjournment, and learned court fixed the matter on 4/8/2023 for hearing of the charge. On 4/8/23, charge were framed against the accused persons. Under section so the learned court fixed the matter on 31/8/23 for physical protection and PWs. On 31/8/2023, PW Sri Biswajit Bora, Senior Intelligence Officer, and Sri Diken Pegu, Senior Intelligence Officer, came to the Honorable Court on receipt of summons but could not be examined, and the matter was fixed on subsequent dates on 14/9/2023, 27/9/23, 11/10/23, 25/10/23, and 8/11/23 for production. On 8/11/23, Learned Court issued fresh summons to the accused persons, and the court fixed the matter on 11/1/2024 PWs. On 11/1/2024, the PWs could not appear due to urgent official duty, and the court fixed the matter on 3/4/2023. 24 for PWs. On 3/4/24, one PW Sri Vishwajit Bora, senior intelligence officer, appeared before the honorable court, but he could not be examined as the PO was transferred, and the matter again fixed on 24/6/24 for PWs. It is stated due to the transfer of learned judge, the learned court, additional session judge number 3, Kamrup, was vacant for a long period, and as such the PWs could not be examined. Moreover, the petitioner also took few adjournment initially, so there is no intention or lapse on the part of the prosecution while conducting the case expeditiously. Now, Lordship, the next date is fixed on 22/5/2025 for examination of further witnesses. So this is the affairs of with regard to now Lordship, my learned friend says that there is no ground of arrest was submitted. Lordship, since page 29 may come to page 31.
Page 31, yes.
Yes. The arrest memo with respect to one accused, Dalurao Amar. She was seen. First address is her name is given. Then address Sri L. Mar, son of Sancho, is hereby arrested by me at 5:17 hours on 22/11/22 under section 42 NDPS Act on the reasonable belief that he has violated the provision of section 8 of NDPS Act and thereby committed an offence punishable under section 20B so and so of Narcotic Drugs and Psychotic Substance Act 1985. He has been duly apprised of the ground of his arrest, and his arrest had been intimated to his wife Srimati so and so, phone number so and so over phone.
Over phone. Over phone, man.
Brother, let me submit you. You got your chance and you will again get your chance.
Please over phone.
I'm reading, I'm not hiding anything. I'm reading everything. But if this is not good, then brief facts of the case, acting on specific information. But I'm again reading that first paragraph. He has been duly apprised of the grounds of his arrest. Then his arrest had been intimated to his wife also. Phone number is given over phone. Then brief facts of the case, acting on specific information. One red colored Tata Nexon car being registration number so and so was intercepted near Jorabat flyover Kamrup Metro, Guwahati on 21/11/2022 at about 19:30 hours. On checking the said vehicle, who specifically built cavity below the rear seat of the intercepted Tata Nexon car were found in the said cavity. A total 16 numbers of showcase were found. Inside each showcase, a polythene sachet containing pinking powder substance was found. Heat seal, primarily test for narcotic drug test detecting kit indicate the positive result of heroin. The 16 numbers of showcase were contained heroines weighing about 92.3 grams, along with the said Tata Nexon car being registration number so and so were seized by number so and so for contravening the provision of so and so. Then particulars of the accused person has been given. Then below, signature of the person arrested. He put his signature, then thumb impression, then signature of witness is there. Then signature of intelligence officer is there. Next page is arrest memo with respect to with respect to another accused. That is also that everything has been written here, Lordship. So in my humble submission, Lordship, nothing has been violated, no provision has been violated. And Lordship has seen he was arrested in 2022 and trial is continuing, and I have read out how the trial is proceeding and for whose conduct Lordship trial is delayed. Everything is mentioned here, Lordship. So in my motion, Mr. Lordship, the petitioner is entitled to bail, and I have submitted some judgments
Marked,
with regard to Lordship.
relevant paragraphs are marked, no?
Yes, yes. And Lordship, with regard to Ravi Prakash, Lordship is in paragraph 2. Lordship, he was sitting in the truck. Nothing was recovered from him. Here, admittedly, the contraband was seized from the both the accused persons, Lordship. And special cavity was made. Yeah. To state of state by NCB Bengaluru versus Pallaludi Ahmad Amirtullah. 2022. Paragraph 11, Lordship. In this case, Lordship, what happened? 3 accused were granted bail by the Bangalore High Court. Then matter went come to the Supreme Court. Supreme Court says that I am reading specific paragraph that this aspect has been completely overlooked while passing the order dated 8 January 2022. Here the only reason appears to have been rated by the High Court for releasing the accused bail is that case in hand on the same footing of accused number A1, A2, and A4, who has been enlarged on bail by order dated so and so. In this connection with the second case registered by the department, we are of the firm view that accused number 2 cannot seek parity with the aforesaid accused co-accused, and no such benefit could have been extended to him in view of section 37 of the act when he was found to be in conscious possession of the commercial quantity of psychotic substance as contemplated under NDPS Act. This being the position, then his bail was rejected. And Lordship, recently, Honorable Supreme Court in case of NCB versus Kasi, in paragraph
Kasi?
30 yes,
Yes.
paragraph 39. I'm reading the 39 1 and 2. The upshot of the above discussion may be summarized as under the provision of NDPS Act are required to be interpreted keeping in mind the scheme, object, and purpose of the Act, as also the impact on the society as a whole. It is to be interpreted literally, not liberally, which has ultimately frustrated the object purpose of the preamble of the Act. Then 2, while considering the application for bail, the court must bear in mind the provision of section 37 of the NDPS Act, which are mandatory in nature. Recording of finding as in mandatory section 37 is known for granting bail to the accused involved in offences under NDPS Act. And Lordship, my learned friend is relying on 2 judgments of Honorable Supreme Court. Lordship is to see the facts of this case. It cannot be applied in every case as a universal judgment, Lordship. And Lordship, another submission is made by the learned counsel in another case that in case of in Radhika Agarwal, Lordship, the matter was relating to GST. That,
Yes, yes.
Yes, Lordship, that
GST.
the provision of the GST was upheld. And while
And that GST, this provision is relating to, because most of the cases are cognizable, non-cognizable offences.
Lordship, that is the entirely different judgment. On Lordship, in that case, Lordship, the provision of section 69 was put under challenge.
Non-cognizable offence.
And Supreme Court says that ultimately upheld the provision of section 69 that arrest can be made by the GST authorities. While making this judgment, Supreme Court observed that judicial review is not applicable, not available to the petitioner here and there. If there is a minor mistakes, that can be corrected. So universally, we cannot apply any judgment anywhere, Lordship. And Lordship, here in this case, the case was he was arrested in 22. Charge sheet has been filed, and evidence is going on. Never this grounds were taken before this honorable court as well before the trial court also. And it is admitted fact, Lordship, in case of that Allahabad High Court judgment, Supreme Court says that regarding trial, Constitutional Court cannot direct any court to finish a trial because there are many factors for dealing the trial. Also. Sometimes it is due to the prosecution default, sometimes by the accused person. And one argument is made that when the accused are behind the jail, how they can delay the trial. But the circumstances says that, as I read out,
Your lordship, there was no counsel. They were given the assistance of the amicus curiae, but they refused to take. They said they will oppose their own counsel. But even then, for a long time, they didn't appoint any counsel lords. And sometimes court was not there. And witnesses were present, but they could not be examined due to paucity of time. So who will be held responsible for that, if that circumstance? My humble submission, lordship, when the trial is coming, yes, we are taking all the inwards to finish the trial as soon as possible. Sometimes, sir, lots of factors are there which are beyond the control of the prosecution side also. When view of the same lordship, the bail is lack of any merit and is liable to be checked.
Well, one thing, so far, section 37 of the NDPS is concerned, there is a bar, the rigor of 37. So the two judgments which have been passed by the Supreme Court, one in Probir Purkaista, that is I have marked as 6,
Yes.
and the other one is Bihanpur. And so far, Probir Purkaista is concerned, my lord, it relates to UAPA. So section 37,
Yes.
same as for it is a
Special acts.
special act 43D, my lord, same thing. The rigor is there, my lord.
Yes.
And in another case, and the other case, my lord, the Vihan Kumar, it is PMLA. And there, my lord, section, my lord, PMLA, I think. my
There
lord,
also there is one.
there is section 37 and PMLA section is ditto, my lord. Not a single, my lord, comma or full stop has been removed. So in those cases, bail were granted. And so far, my lord, 50A is concerned, which I have annexed to my petition, my lord. One submission my learned friend has raised, my lord. Then I delayed, I have done nothing, my lord. In fact, their duty is to do so. CRPC 50A says you have to inform me. So you can take a lawyer under what section, under what circumstance I have arrested. But that was not followed, with all respect, my lord. 50 and 50.
Arrest memo, everything is written in arrest memo.
Grounds of
Grounds
arrest.
of arrest are all mentioned.
No, my lord, grounds of arrest are not there, my lord.
In the arrest memo, it is
No, my lord. To my understanding, my lord, not, my lord.
fully.
My lord, he is under what circumstances he has been arrested. But the apex court in the Vihan Kumar and the Probir Purkaista, it is stated, my lord, section 50, 50A, that is 47 and 48 of the BNS should be followed. And it is not, my lord, by way of phone or verbally, my lord. It should be in writing. In Vihan Kumar's
It's in
case,
writing also.
in Vihan Kumar's case, my lord, in
It's in
Vihan,
writing,
no, my lord,
not arrest memo.
to the wife, my lord, over phone.
No.
Yes,
The
my lord.
accused.
No, my lord, page 31, my lord, he read out, my lord, he has read out, my lord. And his arrest had been intimated to his wife, Srimati so-and-so over
It's in
phone.
writing and he has given his signature.
No, that is an arrest memo, my lord. But where about section 50 and 50?
Section, that is in addition, in
In
addition
addition.
to section 50.
Yes, but 50,
So grounds of arrest may be mentioned, recorded anywhere.
no, my lord. But to my humble submission, my lord, to my understanding, my lord, in Vihan Kumar and
So that is what
in Probir
what I
Purkaista,
understand. What
my
I
lord,
understand.
Probir Purkaista,
It is not required to be mentioned. It is in addition. Section 47 BNS and section 50 CRPC
yes,
is in addition.
yes, man. But it is not there, my lord. 50 is not followed, man.
It's followed.
And my twofold
Grounds
submission,
of arrest is followed.
my twofold submission, my lord. One is the long incarceration, my lord. Article 21 is violated. my lord.
Yes, long
That
incarceration.
long
is-
incarceration that is violated, and 50, my lord,
It is
50,
there. Long incarceration cannot be denied. It is there.
my lord, that is there, my lord. I have given those judgment, my lord. Lordship, my
Let's
counsel-
see.
my
Let's
lord,
see.
my lord. And my lord, to be honest, my lord, in fact, after the trial started, one day we have taken time, my lord. That is true, but because of the change of the council. And out of 11, my lord, only 3 were examined till date. I have given.
Very slow progress.
Yes, ma'am.
No
I have given
doubt about it.
all those judgment, my lord. That is there, madam.
Let's see, let's see.
Madam.
I'll have to ponder over it.
Right.
That,
Lordship,
let's
just
see the
one-
type of case.
one clarification, lordship.
Yes, yes.
Page 29, lordship.
Page 29 again.
Yes.
Notice under section 50.
Mm.
Married lordship.
Yes, yes.
CRPC.
Name of the accused's address is there, the reference case number is mentioned. In exercise of power conferred under subsection 1 of section 50 CRPC, I hereby inform you that during the investigation of DRI case number so and so, dated so and so, under section 42 of NDPS Act, you are found involved and arrested in connection with the above mentioned case, reference on 22/11/22. So you are favored to honorable court forwarded to annual court. You may submit petition for the annual court. His signature is there.
This is not a case of grounds of arrest. This
No,
is a
madam.
case of long incarceration.
No, my lord, still I argue my lord on this
No,
one,
no.
my lord. My lord, there is two different,
No,
no, no, only
not
my
a case of grounds of arrest.
my lord, one thing. my lord.
Yes, yes, a case of long incarceration.
Yes, my lord, other one for administrative purpose, my lord, I'm saying. But the reasons of arrest and grounds of arrest has been,
I have read
yes, my lord,
judgment over and
here,
over
my lord, it is
again.
grounds of arrest, my lord, 50 page.
I have read it, the
Yes.
judgment over and over again.
Yes, my lord.
But now we are only on Vihan Kumar
Right.
judgment because COVID cluster was discussed and then the decision was arrived at.
Yes, my lord.
So both are the division
So
bench
there,
judgments.
so there is a distinction between, my lord, the grounds of arrest and reasons of arrest.
That Radhika Agarwal's case is 3-page judgment, but that is relating to GST, so it won't apply here.
I leave it to your lordship, long.
Lordship, this is the-
prolonged
But long
Yes,
incarceration,
my lord,
yes,
that one.
you have a
I'm
point.
obliged, my lord.
Lordship,
Yes,
this is the problem now, Lordship, different judgments have come. All contradictory judgments are there. And Lordship, we go by the
No, no, but
interpretation.
this is not contradictory.
No, no,
Radhika Agarwal's judgment is not contradictory. This is
no, Lordship.
relating to 3-judge bench
No, no,
judgment.
my submission with regard to long incarceration also, some judgments are pronounced, where no discussion is made, so we cannot take these judgments as a precedent, Lordship. And Lordship, the situation is.
No, 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 no. Without discussing, we will not take as a precedent.
Yes, Lordship, this is the problem, Lordship, in different judgments, it has been relied on.
Yes.
So if we go by the strict interpretation of.
Without coming to a point, without discussing and observing and
Anything, Lordship, it
uh,
cannot be treated as a,
holding and setting aside certain points, then we cannot take
it
it as a
cannot be taken as a
precedent.
precedent, Lordship. This is my humble submission.
Yes.
And regarding the Lordship, when we are applying any precedent, then first we have to consider the facts of the case.
Mm.
And relying on some here and there, Lordship, that will not do. And
No, no.
by Lordship, by
Yeah, long incarceration, he's got a point, but grounds of arrest, he hasn't got any
no,
point.
Lordship, with regard to long incarceration also, Lordship is to see for whose default. Lordship, in case of Manish Sisodia case, Supreme Court has clearly stated that the court has to see for whose default the trial is being delayed. And Lordship, this is the NDPS cases, Lordship. And everything we cannot accept that every same formula will be applicable in all the cases. And we also owe some responsibility to the society also, as stated in the Kasif case, Lordship. This is my answer.
But if it is held by the Supreme Court, then we can't help it.
No, definitely, Lordship. But Lordship, we have to see what is the law, under what circumstances the order has been passed. In the Prakash, Lordship.
No, but if all are brought in, all the even if the special acts are also brought in the same judgment,
Yes,
then
Lordship.
we'll have to follow.
No, definitely. But we have to see, then again, Lordship, then we have to consider Kasif judgment also. That is also by the 3 judges bench.
Yes.
The purpose of the recently on 17th of April, Supreme Court has passed a judgment. Considering all this aspect, I'll place on next day, Lordship. It is also very beautiful, written, beautiful judgment by the Honorable Chief Justice of Supreme Court.
The Radhika was.
No, another case. It is matter relating to a granting of bail or bail not with respect to Companies Act. Some beautiful observation has been made. I'll place this judgment also.
You were talking about which judgment, 3-judge bench, that Kasif judgment?
No, Radhika is a different case.
GST, because GST
Recently,
all
Lord,
offenses are
in
non-cognizable.
the month of April,
Most of the
2 judgments have come. One with respect to NDPS Act, the very beautifully written judgment. I'm just reading out, it's a very long judgment, about 65 pages. And some very beautiful observation is made with regard to all these things. Because ultimately, we also owe some responsibility to the society also. Following some detour line, we will not do, because we are harming the society also.
Definitely.
That is the main purpose of the. This is my purpose.
Definitely, this is NDPS cases. It's a slow poison.
No, that is there, Lordship. Delaying the trial after BNSS, Lordship, the witnesses are examined through video conferencing also. So probably within a very few days, this problem will be solved.
We had video conferencing before BNS also.
No, Lordship, now it is.
We were taking a.
Now by law, it has been made mandatory, Lordship.
No, but we were you.
No, earlier it was there, but
We
it was,
used to take a just of justice leaves the matter or not.
In this case, my lord,
Mm.
we have been in custody even without committing any offense, my lord. If your lordship go to the records, my lord, we are the victim of our religious identity, nothing else, my lord. May you read that. My lord, kindly see the FIR first, my lord. Page 10, my lord. Page 10, my lord.
CD you have not received.
Not received, madam.
My lord,
Ah.
if my lord, if your lordship go to the records, my lord, or go to the primary civil petition, we are innocent, my lord. A
Page
past,
12, okay.
yes, my lord. One fanatic groups have filed an FIR. The victim has not filed FIR. Relative of the victim also not filed FIR. They are not willing to file FIR because not any offense has been committed. Even the 161 was not made by the victim. They cannot show, my lord. It is only because of our religious identity we have been in jail, my lord. Kindly see the FIR, my lord. Page 10.
Hmm?
My lord,
Hmm?
my lord, my humble submission, my lord, your lordship, go through the my privacy records and your lordship may pass interim order. If you if
Not granted earlier, madam.
How many days you are behind bars?
I have been bar my lord since 24/3/2025.
Ah.
Today is almost 1 year or one month, my lord. And not even 1 month, my lord.
What is the offense?
Offense, my lord, kindly see. I may be hard, my lord, your lordship, kindly see.
Okay.
Page 10, my lord. At least I may be hard, my lord. To the officer in charge, Karimganj Police Station, complainant Amit Chakravarti. It is Amit Chakravarti, son of Ananta Narayan Chakravarti, village Biscuit, post office Salabari, pin number sensor, district Sribhumi. With due respect, I beg to state that 123/3/2025 at about 6:30 p.m. I, along with some workers of Hindu Rocky Dal of Sribhumi town, while going towards Karimganj bypass for organizational works, heard noise from the beneath of the bypass bridge. Then we saw that accused person misbehaved
20/07/2020. Cognizance was taken on 19/9/2020.
Cognizance is not required. Okay.
Yes, lordship. And lordship, dear lordship, altogether 5 persons are named in the charge sheet.
Hmm.
And lordship, 1 person is absconding. Against him, NPWA was issued, and now lordship, perhaps he has appeared, and that information I don't have. So lordship, my first ground is lordship,
Hmm.
long incarceration, 2 years and 22 days.
Hmm.
Apart from that, lordship, in the present case,
Hmm.
FIR was lost on 22 March 2023. The petitioner was arrested on 31/3/2023 after 9 days. The petitioner was arrested only because of the reason that his vehicle was used by his younger brother. Nothing was recovered from the possession of the petitioner. And lordship, on the last occasion, lordship,
Hmm.
I have gone through the statements of the other co-accused persons.
Hmm.
My learned senior friend is at best position to apprise this honorable court. Perhaps, lordship, co-accused person, all the other arrested person have stated nothing against the petition.
Okay.
So, lordship, so far as the first ground is concerned, lordship, I'm relying on 2 judgments, lordship.
এটা হলো করলে ভালো জিনিস বর্তমান লাগছে আপু অন করে দিব suddenly it gets very cold. Hmm. Long incarceration.
Yes, lordship. One judgment was passed by your lordship, relying on this Dhirendra Kumar Chaudhary's judgment. Lordship, may kindly pick up the Dhirendra Kumar's judgment, Lordship. Criminal Appeal 3379. I'm reading only two paragraphs, Lordship. Leave granted. We are inclined to set aside the impugned order only on the premises that trial is yet to begin and the appellant has been under incarceration for 17 months. Thus, on the principle of right to speedy trial, we are inclined to grant bail to the appellant. Accordingly, the impugned order is set aside and the appellant is granted bail on terms and conditions to the satisfaction of the trial court. Relying on the judgment, Lordship was pleased to pass that order, Lordship, in
This was, I think this date has been wrongly mentioned here.
Yes, Lordship, that this date is wrongly mentioned, Lordship, at the very first paragraph, Lordship. Here, Lordship, the petitioner was, Lordship, subsequently, Lordship has mentioned the term, Lordship, that was 1 year, 10 months. And Lordship, this date, Lordship, perhaps, Lordship, it would be 2024. And it was a typographical error. So, Lordship, only on the this ground, Lordship, long incarceration, I am not going to rely on
Grounds of
other
this,
judgments, Lordship, Robi Prakash, on all the other judgments, Lordship. These two judgments specifically. And another argument, Lordship, is that whether there is any delay or any fault on the part of the petitioner. For that, Lordship, here the petitioner was arrested and since then, Lordship, he is in custody and before that, Lordship may kindly come to paragraph 9 of this bail application number 3015 of 2024, Lordship, Jubel Hussain. The previous one, Lordship.
Okay.
Lordship may kindly come to paragraph number 11, page number 5. Or Lordship may allow me to read the paragraph number 10 also.
Okay.
I have considered the length of detention. The petitioner has been behind the bars for more than 1 year and 10 months. Though, Lordship, the date has been mentioned as Lordship 2025, here, Lordship, it has been corrected. Not a single witness has been examined so far. It is true that the petitioner was intercepted while he was carrying 300 grams of suspected heroin. So, Lordship, there the petitioner was arrested with the possession of heroin 300 grams. Here, Lordship, in the present case, Lordship, nothing was recovered from the possession of the petitioner. And he is booked in a serious offense. But at the same time, it is apparent that trial has been procrastinated by the state as well as by the court. 8 witnesses are enlisted in the charge sheet as cited witness and not a single witness has been examined so far. I have relied on the decision of the Honorable Supreme Court in the case of Dhirendra Kumar Chaudhary versus State of Assam in criminal appeal number so-and-so, wherein by order dated so-and-so, the appellant
How
so-and-so.
many witnesses are enlisted in the charge sheet?
Lordship, in my case, Lordship, total cited witness, Lordship, is 15. 15.
What is the contraband?
Contraband, Lordship, is heroin, 1 kg 526 grams.
See, this is a very serious offense. Heroin 1 kg 526 grams, very serious offense.
And Lordship, that was recovered from other person. The petitioner was arrested only for the reason that his vehicle was used by his younger brother who was arrested, Lordship. And Lordship, his younger brother is not before the court, Lordship. This petitioner was arrested, Lordship, after 9 days.
I think this case, I think it is not relating to heroin. I'm sure this case is not relating to heroin. 1.5 kg heroin, very serious offense.
But Lordship, at the same point of time, Lordship, the petitioner was not there. Neither from his possession anything was recovered. Lordship,
Charge sheet has been submitted against him, no?
yes, Lordship. In the charge sheet also, Lordship, even Lordship, in the forwarding report also, even in the FIR also, there is a mention that the name of the petitioner has been inserted as because Lordship, the petitioner is the owner of the vehicle which was used by his younger brother, Lordship, who was arrested red-handed, Lordship. Lordship, may kindly go through the witnesses or examine the witnesses, Lordship, those have been examined by the IO, Lordship. Lordship, may kindly go through their statement also whether anything has been said against me, Lordship.
No, no, you come after a few days. In this case, I'm sure this is not heroin. You come after a few days, not with 1.5 kgs of heroin. No.
Then, Lordship, my second claim of argument would be ground of arrest. Lordship, may for that, Lordship, I am seeking an adjournment, Lordship. I will argue the case in the next week,
Okay.
Lordship.
List the matter on. One and a half kgs of heroin is very serious offense.
But, Lordship, that was not recovered from my possession, Lordship.
I understand. I am telling you, you come after a few days.
Yes, Lordship. Even, Lordship, earlier, Lordship, on 2 occasions, my bail petition was rejected. This was the third bail. And, Lordship, 2 years and 22 days. Lordship.
You see, when I'm granting bail, most of the
Yes,
cases,
Lordship.
these
I'm not
cases
pressing,
are
Lordship. I'm not
ganja.
pressing.
Most of the cases are ganja and 411 kgs of ganja, or this type of.
I'm not pressing, Lordship. I will argue
Okay.
on the next claim, Lordship.
Come next time, maybe we'll consider.
Yes.